All right, I think we'll get started. And if people show up, they can join us. So, officially, I'm Jim Condos, Vermont Secretary of State. With me is my deputy, Chris Winters. My background, I have 18 years of local city council experience, 8 years in the state senate, chaired 2 committees, education and GovOps. And I've been Secretary of State since 2011. And we started this program, or this transparency tour, in 2011, the fall of 2011, and we've done it each odd year. So it's actually, we do it the off year from the election. And the whole idea behind it is for education purposes. It's just to give an education on both the open meeting law and on public records access. And it was because we realized, well, there was a lot of changes made in 2011 and 2013 to both laws, and we realized that, especially at the local level, folks just didn't know what the law said, and we're just here to educate. We're not here to play gotcha, we're here to educate. So we'll get started. As we just discussed, that is a shot of Plymouth, Vermont. But why are we here? Democracy, accountability, and openness. The public has a right to know. And you will see me say that quite a bit throughout this program. Open meeting and public records laws protect our direct access to the very decisions that affect us, and understanding these laws makes everyone a better citizen. Ultimately, the boss is the public, and that's inscribed in the Vermont Constitution, Chapter 1, Article 6, that all power being originally inherent in and consequently derived from the people, therefore all officers of government, whether legislative or executive, are their trustees and servants, and at all times accountable to them. Also, this is the Section 311 of the statute of Title I is the Declaration of Public Policy for the Open Meeting Law, and that basically says that it's the public commissions, boards, and councils and other public agencies in this state exist to aid in the conduct of the people's business and are accountable to them. It also, both of these statements reference back to Chapter 1, Article 6 of the Constitution. This is the Public Records Access Statement of Policy, and it talks about the public's right to free and open examination of records, that officers of government are trustees and servants of the people, and it is in the public interest to enable any person to review and criticize their decisions, even though such examination may be inconvenient or embarrassing. So we're going to talk about open meetings first, and we'll follow that with public records access. It doesn't take a whole lot of time, but we'll try to make it as quick. If you have any questions, ask as we go. And if you do, please come up to the mic so that the TV station can make sure that they get your voice as well. So who must comply? Public bodies of the state and its municipalities. That includes state and municipal boards, councils and commissions, committees and subcommittees of those. Not included are individual officials, councils established by the governor exclusively for policy advice. The Judicial Branch and Public Service Board are both exempt from the open meeting law because they have their own rules that they follow, and generally nonprofits. And I think Representative Morrissey, I think you probably are aware that most nonprofits, they either have a set of charter or bylaws. So in order for them to have to comply, it doesn't matter how much money they get from the state or the feds. It's whether their charter or bylaws actually states that they have to follow the public record, or the open meeting law, or if there's a string attached to the money that is given to them. A good example of that was from Vermont Public Television about 2 years ago. There was a little fluff up in Chittenden County with it because they were meeting behind closed doors, and it was discovered that the money that they received from the Centers for Public Broadcasting actually had strings attached that said they had to operate in the open meeting. So they do now. When does it apply? It applies when there's a quorum holding a meeting. So what is a quorum? It's a majority of the entire public body. So if you have a 3-member select board, it's 2 members is a quorum. If it's a 5-member select board, it's 3. A 7-member would be 4, and a 9-member would be 5. Also, a meeting is a gathering of the quorum of the public body for the purpose of discussing any business or taking action. Essentially, what that means is that if you have a quorum and you start discussing town business, you need to be in a meeting. You're in a meeting, and you need to have it publicly warned. A meeting can occur regardless of physical location. There's no exceptions for work sessions or retreats. A lot of boards, I know over time we get calls, well, we want to hold a work session and we don't want the public to be involved. Well, you can't do that. There's no such thing in either Robert's rules or in the statutes that recognize work sessions or retreats. The key words are, do you have a quorum? And are you discussing town business? A meeting can also come together over a span of time. So you have to be careful about email strings and social media discussions. And for example, it is okay to communicate with each other when you're trying to organize an agenda, distribute materials to discuss at the meeting, or schedule a meeting. That's okay, that doesn't constitute a meeting. But the minute if you had distributed these materials and someone hits reply all and you start discussing it amongst yourselves, you're now in a de facto meeting. Although we haven't had any court cases, we believe that that's how the court would rule. The legislature may take that up this year, we don't know. We think they might because there's been a lot of question about it. But both VLCT and us agree that it's, at this point, we need to be conservative about it. And about this, regardless of physical location, you could have 3 members of a 5-member select board meet at the coffee house on Saturday morning. And as long as they're talking about baseball or football, they're fine. If they start talking about the budget or anything else that they have authority over, then it becomes a meeting, an unwarned meeting, and they need to be very careful. As far as what kinds of meetings are there, there's regular meetings, special meetings, and emergency. Regular meetings is where you adopt a resolution or take an action as a board at your organizational meeting, and you say, we're going to meet the first and third Mondays at 7 p.m. at the town hall. So you've got first and third Mondays already designated, you've got 7 p.m. and you've got town hall. If any one of those 3 changes, if you meet at 6:30 instead of 7, then you should fall under the special meeting provision. You do have to make an agenda available 48 hours, but we're going to talk more about agendas in the next slide. And in special meetings, you need to notice it at least 24 hours ahead of time. You should contact the newspaper or radio station serving the area, even though you may have missed a deadline, you still need to contact them. And any person who may have in writing asked to be notified of any special meetings. You have to post that agenda 24 hours in advance. And emergency meetings are only really for act of God, unforeseen situations that may create a situation where either a safety situation or an immediate need that has to be resolved, for instance, a fire, flooding. And you just have to give some public notice as soon as possible before the meeting, but you're not required to do it 48 or 24 hours ahead. Just get some kind of notice out there, post it somewhere. And I'll just say this, in Vermont, in 2011, probably about this time of year, in 2011, we had hundreds of emergency meetings going on around the state. And that was after Hurricane Irene visited and left us, and we were trying to overcome and recover from that. There were some towns who they were meeting at the culvert on the south side of the city, at the bridge on the north side, and maybe at the town hall as well, trying to discuss how they're going to get the town back open and moving. Agendas. Agendas need to be posted at least 48 hours ahead for a regular meeting and 24 hours ahead for a special meeting. If the town designates or maintains a website, they must post it on the website, as well as in the town clerk's office or near the town clerk's office, and in 2 other designated places. And they need to make it available to any person who requests notice specifically. What else should be done? The agenda should address the specific topics to be discussed and potential actions. And the first item on the agenda should be, are there any changes to the agenda? Are there any additions or any deletions? I will say that, although it doesn't say it in the statute itself, best practice would say that if you're adding something to the agenda, make sure that it is, that you're not taking an action on it, that you're only warning it you're taking it in for information purposes, and on your next agenda, we'll warn it for action. The reason being, you could play some hanky-panky with it, where a town, maybe there's a contentious item in town, and they don't really want to just put it on the agenda because they know people are going to show up, so they wait until they have it off to the side, and they come to their next select board meeting, and lo and behold, there's no public there. Let's add that item to the agenda and discuss it and pass it tonight. That way they don't have to take any testimony from the public. That's the spirit of the law, is that the public has a right to know. Keep that in mind. Minutes. Minutes have to give a true indication of the business of the meeting, covering all the topics and motions. They do not have to be verbatim. We've had people call us and say, hey, I stood up at my select board meeting and I raised my hand, that was recognized, and they didn't even put in the minutes what I said. They don't have to. They just have to give a true indication of the meeting, covering all the topics and motions. At a minimum, they need to list the members of the board that were present, any active participants, so they should have a list of people who were there, and any motions, proposals, resolutions, and dispositions, and what the results were. The minutes have to be posted no later than 5 calendar days after the meeting, and this has not changed in 30 plus years. What changed was, if you have a website, you must post it on the website as well. And that was what caused the kerfuffle amongst some towns, especially up north. They didn't want to have to deal with it if they have to post it, because it's so hard to put something up on their website. We had one town say, I'm going to have to hire someone full-time just to manage the website. Not in today's world. It's point, click, and it's up, so. Executive session. Executive session is when a board meets in private. It's a closed portion of the public meeting. The public is not involved or invited in. It is appropriate only if the business to be considered fits into one of 14 statutory categories. And the public body must actually open or be in a public meeting first, a properly warned public meeting, before they can have a motion to go into executive session and then go in. They can only talk, no action, except for one item, and that's real estate options. Some of the permissible reasons require an additional specific finding that premature public knowledge would clearly place the public body or a person involved at a substantial disadvantage. This statement should lead off any of these 6 items here, which contracts, labor relation agreements with employees, arbitration or mediation, grievances other than tax grievances, civil litigation or prosecution, and confidential attorney-client communications. So those are the first bunch that actually connect with this statement. And then there's other reasons, and as I said, negotiating or securing the real estate purchase options, which is the only item that you can actually approve in a executive session. Any appointment, employment, evaluation, discipline, or dismissal of a public officer or employee. Any student academic records, suspension, or discipline is allowed to be in an executive session. If any of the documents that you're using are exempt from public records in any way, then you can use this one to get in for that. A clear and imminent peril to the public safety. And the last one was added, municipal or school security or emergency response. That was added after Sandy Hook a couple of years ago, and it was felt that the legislature rightfully felt that it was important to not to give the bad guys your plan, your security plan. You can also meet by electronic means as the world is changing, and I often say this, technology moves much faster than government does. Technology changes every 3 to 6 months. Government sometimes takes years to move. If you come on in. There's a handout right behind you if you want. Oh, you're in the other room? Okay. A member participating remotely must identify himself or herself when the meeting starts and must be able to be heard and hear throughout the meeting. So if you have someone that's away but they want to participate, you can set up a conference call or a Skype on a computer, but they have to be able to be heard by everybody in the room, plus they have to be able to hear everybody talking. If a quorum or more, and it is possible that you could have a quorum participating remotely, if something comes up and it's in the middle of the summer and people are away on vacation, the agenda must actually designate the physical location where the public can attend and participate. So you might say the town office, the town manager's office or something, and one member or some designee must be physically present to make sure that everything is up and running and working. Any vote that's not unanimous must be taken by a roll call. Public participation, and this is one of the important pillars of the open meeting law. Members of the public have a right to attend, to participate, and as far as attending, they have a right to get meeting agendas in advance, to be notified directly of upcoming special meetings, and any disability accommodations that must be followed. To participate, and this statement comes right out of the statutes, a reasonable opportunity to express opinions on the matters being considered, subject to reasonable rules. So let me give you an example where you could have reasonable rules. When I was on the city council in South Burlington, we would we had a $10 million operating budget. We would hold our public hearing, and we'd have 2 members of the public show up for a $10 million operating budget. 2 weeks later, we were going to have a meeting to discuss the leash law on the bike path. And we would have 150 people show up, 75 people were for the leash law, 75 were against it, and everybody wanted to speak. What did we do? We set a sign-up sheet and said that if you want to speak, you have to sign up. And then we went through the list and we allowed everybody to speak for 2 minutes. We were there for a long time that night, but everybody got a chance to speak. And that's really the right thing to do, because again, the spirit of the law is that the public has a right to know. I always say the simple way to say it is the public has a right to know, to attend, and participate. So why should we comply? Because meetings held without respecting the details of the law may be considered illegal, and if so, the courts may regard any action taken during those meetings as voidable. Generally, what the court would do is tell a town to go back and do it over. Just to continue on this a little bit, illegal meetings do offend our notions of openness, accountability, and our democracy. In Vermont, the people rule, sometimes directly, sometimes through their elected or appointed reps, but always with the benefit of public scrutiny. So why comply again? The following people can be charged with a misdemeanor and or fined. A member of the public body who knowingly and intentionally violates the open meeting law, a person who knowingly and intentionally violates the open meeting law on behalf of a member of the public body, or a person who knowingly and intentionally participates in the wrongful exclusion of a person from a meeting. And any aggrieved individual or the Attorney General can bring a suit in court seeking injunctive relief, declaratory judgment, and attorney's fees. We haven't seen any of that happen, but usually if someone charges that there's been a problem, they will usually get... You're looking for the firefighters?
Yeah.
That room. Usually if a lawsuit is filed, the town that's involved will find a way to remedy the situation before it gets too far. Enforcement, a written notice to the public body by either the aggrieved individual or the Attorney General alleging the specific violation. The public body then has, their public response needs to be within 10 calendar days, acknowledging the violation and stating their intent to cure it, or stating that they don't believe that they violated anything. If they intend to, they state that they're going to cure it, they then have 14 calendar days to provide that public response, ratifying or declaring as void the action that they took. So you would declare void any action you took at the previous meeting and adopt specific measures to prevent future violations. Aggrieved individuals do, if they don't like what happened, they still have 1 year to go to Superior Court and file a claim there. So that's the open meeting law. We're through that section. That was pretty quick. But do you have any questions on the open meeting law? If not, we'll move to the public records, which doesn't take quite as long. So public records. So what is a public record? It's any written or recorded information, regardless of the physical form or characteristics, produced or acquired in the course of public agency business. It can be any format at all. Remember, records are not limited to just paper. It could be digital, it could be... Maybe you should go over there, Mary. All government, and this is a key point here, is all government records are public records. All records that the government collects is public. Some of those public records are exempt from disclosure, and we're going to get a little bit into that. So, who has to follow the law? All public agencies of the state and its municipalities, state and municipal agencies, boards, departments, commissions, committees, branches, instrumentalities, and authorities. Again, usually not included are nonprofits unless it's in their charter. Who can ask to inspect or copy a public record? Anybody. And when we say anybody, we mean it could be anybody within the town, from the next town, from the state, or from the next state, or from overseas. It doesn't matter, anybody. And there's one difference between that and a school board. A school board does have a little bit of a restriction where it's only those people who are members of that school district. So those are the people who can request information. This statement was in a Supreme Court decision versus the City of Burlington. The identity and motive of the requester cannot be considered when weighing access to public records. Essentially what that means is it doesn't matter what they want it for. If it's a public document, you have to give it up. How do you make a request? You can inspect records at the state during a week, 9 to 12, 1 to 4. If it's a municipal record that you're looking for, during their customary business hours. Now, I know that Bennington is probably open 5 days a week, but there are some towns that are only open 1 day a week. So you can't just make them come in on their off day. They come in when they normally would come in. You don't have to, except in specific situations, but we think it's a best practice to ask for the public records in writing, because that way you've got your name, your address, or any other contact information. You can be specific as to if it's inspection of the records or copies of the records. Inspection is free, copies cost, and you can better describe the records rather than do it verbally. A custodian of the records, if they're going to give it up, must give it up promptly. There's no definition for promptly, whether it's 1 day, 2 days, 5 days, but it's promptly. There is a provision in there that says, which is on the next page, but we'll talk about it, is if you are going to deny, you can have up to 3 days to deny a record if you're looking at the exemptions. These items right here, we're going to go into in more detail in the next pages, but you can accept the request for public records in any manner or format. If staff time costs are involved, then an agency may require requests to be made in writing. That's one of the exceptions. If necessary, you can also consult with the requester of the record to try to narrow what it is they're looking for. So, some of those exemptions I was talking about, if the item is in active use or in storage, for instance, if someone walks into the town clerk's office and said they want a specific document, town clerk says, well, I'm in the middle of something here on my computer, I'll have it ready for you within 1 calendar week on X day and at X time. And you have to certify that in writing. Pretty simple. If the item is exempt under statute, in other words, there's a specific piece of law that says that that item is exempt from disclosure, you have up to 3 business days to tell people that's the case. But in doing so, you must do it in writing, and you must identify the records that are being withheld, the statutory basis for it, the supporting facts, who are the people that are responsible for the denial, and who can you appeal to. So if someone denies, you can also appeal to the next level. Typically, that would be the head of the agency. If the record doesn't exist, whether it never existed or whether it doesn't exist any longer, the custodian must certify that this is true in writing and state that the record does not exist under the name given or by any other name known. Unusual circumstances, in this particular instance, you can have up to 10 business days to look for the records, and that is if you have to search for and collect the records from remote facilities. For instance, if you have a town hall that's small and you don't have a lot of storage space, but you store it at the Public Works garage or someplace else, and you need time to go look for it and find those records, then you have up to 10 business days. You also, if someone gives you a request for a large volume of separate and distinct records, you can also ask the person to narrow the scope and say, hey, look, if you give me a little bit narrower, I might get the records for you quicker. And sometimes you have to consult with another agency or the Attorney General, depending on whether you're looking to find out if the record is exempt, if it's gray, if the area is gray, or if sometimes records are jointly held by more than one agency. So you might have to consult the other agency. If you're going to delay up to 10 business days, you must give written notice to the requester stating the reason for the extension and the expected date that you're going to be able to comply. So the public agency, the rule is for the public agency is that they must produce the public records for inspection and copying unless the record is exempt under statute. The policy states that it's in the public interest to enable any person to review and criticize government decisions, even though such examination may cause inconvenience or embarrassment. And the burden of proof lies with the Public Records Act, and this is directly from a Supreme Court decision, but now the Public Records Act represents a strong policy favoring access. Essentially what they're saying in this statement, we construe these exceptions strictly against the custodians of the records and will resolve any doubts in favor of disclosure. So what they're saying is if the law is gray and you're not sure whether it's exempt or not exempt, the courts will most likely fall to the side of disclosure, providing disclosure to the public. The burden of proof is on the agency seeking to avoid disclosure. So the person making the request doesn't have to prove anything, they just make the request. The agency has to prove, if they want to withhold it, they have to prove their case to the court. So it's really on the state agency or state government, or its local government to prove that the item is exempt. And that statement came right out of a Supreme Court decision, Wesco versus Sorrell. So, as far as the exemptions themselves, the original 40 some odd exemptions are listed in the Act itself at section 317, but approximately 200 and 220 more are scattered throughout the statutes. Every public agency, whether it's a state or local, should know which, at least the most common exemptions that they need to pay attention to. For instance, you don't want to give someone something with social security numbers on it, with dates of birth, with medical information. And there are 2 locations for resources. Legislative Council has on their webpage, which is on the legislative webpage, has a list of the public records exemptions. And theirs just got updated just last week, so they do it every 2 years. They update it for anything that occurred in the previous 2 years. So they just updated theirs, and then our office has on our archives webpage a right-to-know database. Both of these you can function them using keywords. So you can put a keyword in, and it'll tell you if there's an exemption around that item. What if only part of the record is exempt? You following? What if only part of the record is exempt? So let's say you have a page and it has a social security number on it. Years ago, that agency would not give that record out, period, because it had a exempt record on it. What the legislature did was they updated the records, the laws, and said that you must redact the exempt information but provide the remainder. So what that means is you just black out that item, whatever it is. You have to identify it, why you have this black mark on your record, and you could just say it's got a social security number and leave it at that. Often the press will go ask for police records, and police records, when they get them back from the police department, very often is nothing but black lines. The police will say it's all redacted because it's it's information that can't be exempt, it can't be given to the public at this time. So that's something the legislature also has addressed a little bit as well. Also, does the custodian of a record have to gather new information or create new documents in order to respond to a request? Simple answer is no. A requester cannot obligate the government to create a record that is not already in existence or required by law. And must I withhold a document if an exemption applies? It depends. Sometimes it's not state law, but it might be federal law that you have to follow, so you have to be careful. That's why it's a good idea to know both laws to a certain extent. The safest course is, of course, to err on the side of openness, but always consult with your legal counsel. There are copies and fee charges. If you want copies, the legislature set this as actual cost of providing the copy. Now, we have a uniform fee schedule on our Secretary of State's website. We're responsible for that. And essentially, if a town doesn't have their own fee schedule already approved by their legislative body, by their select board, then they must follow the uniform fee schedule. Uniform fee schedule says 5 cents for a single side paper, 9 cents for a double-sided. I think it's like $1.40 for a DVD or something. But the costs are there, but they all are based on the actual cost. You can include costs for mailing or transmitting the copy as well, and staff time if in providing the copy there's time that directly involves exceeds 30 minutes. The agency agrees to create a new record. So if you don't have to, but if you do agree to create, you can charge for the creation, the time it took to create. And also if you're going to provide it in a non-standard format, and that time also exists beyond 30 minutes. This goes back to the same thing that we said after the open meeting law, that essentially prompt compliance supports our notions of openness, accountability, and our democracy. An agency that denies access to a non-exempt public record may face litigation and could be charged the requester's court costs. The legislature changed this 5 years ago, and now it used to be that the court might award, if the government agency lost the case, the court could award attorney's fees. They didn't do it very often. And so what was created was a culture of deny, because you were gonna have to go to court in order to get the document, and the agency wasn't gonna lose any money. Now, what the legislature did was change one word from may to shall, and if the member of the public substantially wins the case, the court shall award that person attorney's fees. And that's to change that culture. Enforcement, you can always appeal to the head of an agency. You have if you do appeal to the head of the agency has 5 business days to either make the records available, give notice of denial in writing, including the statutory basis and brief statement of reasoning and supporting facts, and further details about the appeal rights. If a denial is upheld by the head of the agency, or there is no head of the agency, or the time limits were completely ignored, you can file in court. And you do have a 30-day deadline there. That's the end of the public records section, and that's the end of our presentation. This is not associated with our office, but the Vermont ACLU and the Society of Professional Journalists asked us to provide this to the public. Essentially what they're doing is they're looking for people who have had experience in trying to get public records, whether it was good or bad, so that they can build their case for further changes to the Public Records Act. Thank you.
Thank you. Thanks.
It's actually pretty simple if you just stay in tune with it. We think it's some of our most important laws, both the public records and the open meeting law. Any questions?
There's a couple. You can always.
No. Can you come up to the mic?
Yeah, go to the mic. Okay, sure. So anyway, there was one. All right. So when you go to look up Vermont statutes online, I think isn't there a kind of a disclaimer where it says that they may not be the actual statutes?
Yeah, there is, because the statutes take time for them to update, and I think they might be now.
Around this, should I go with the mic?
Yes.
It's usually around this time of year that it's gotten from the Legislative Council to the governor's desk to LexisNexis, which is the publisher. So laws passed on July 1 might not be on the books, in the green books yet.
Right.
It's usually around this time that the new publication comes out and the online version at the legislature is updated. So
Sure.
it varies, the time varies as to when it gets up there, the changes from the last
It's
session.
not immediate after the legislative session.
Yeah. Just for the record, my name is Bruce Lonergan, by the way. I was supposed to introduce yourself. The other question I had was people who can request public records, and you indicated that that's everybody. When you say everybody, is there a limitation as to whether or not, clearly it's obvious that within the United States, did you say outside of the country as well?
The law doesn't address that, so our interpretation is that it's anybody.
Okay.
And we do have a court case that says the identity and the motive of the requester is irrelevant.
Wow. I guess my only concern is, that I can see if it was a U.S. citizen, but what would happen if it's not? Okay? Should there be any limitation, as to
That's
access?
a question for the legislature.
Yeah, by a foreign agent of any type.
I
But
mean,
at this time, you're saying, no, there isn't. Anybody can.
according to the law and according to the Supreme Court decision, which follows the law, which reviews the law and then determines the action that should be taken, that is the case.
Okay. Okay. All
And
right.
our job is to interpret the law as it's written,
Sure.
not to make the law.
Sure. Understood.
That's their job.
Okay. All right. Thank you.
You're welcome. Any other questions? Well, thanks very much for coming tonight. We appreciate your attending.
Thank you, and I'm going to leave a couple of business cards by the door for anyone who wants to take one. Representative Morrissey knows how to contact me, but anyone else who wants one, anytime you have a public records question, an open meetings question, elections questions, business registration, we do a lot of different things in the office. You should feel free to reach out to us, and either I'll be able to help you or I'll get you to the right person who can. So thank
And
you.
that website one more time, please?
The website is www.sec.state.vt.us.
Sorry, I took it down too quick.